In this video I want to take a look at indemnities. What is an indemnity and what are the essential features and benefits of an indemnity? It's a word that you might have come across from time to time, and it arises in contracts. It also arises in relation to purchasing houses from builders and so forth. An indemnity is a contractual term which promises to reimburse another party in respect of a loss or damage. The only party indemnified is the one that is identified as the beneficiary of the indemnity. If the benefit of that indemnity is to be transferred to another party, it must be done formally. So typically, in relation to a property in a housing estate, for example, there may be indemnities from the builder to the purchaser of the house to carry out certain works and maintain the place before the council takes the house in charge. And if that house is sold before the council takes the estate in charge, then the benefit of that indemnity must be assigned from the vendor of the property to the new purchaser. So that's what is meant by, if the benefit of the indemnity is to be transferred to another party, it must be done formally. So there would be a deed of assignment or some sort of an assignment, a note or memorandum. How are potential liabilities covered? One, between the parties to the contract, where one party gives the other party an indemnity, and two, in respect of third party claims against the beneficiary of the indemnity. So somebody might give somebody else an indemnity in respect of any third party claims which might arise. What losses will be covered? It will depend on the drafting of the indemnity clause, which can be narrowly drafted or broadly drafted. Direct losses, for example, may be included in a narrowly drafted indemnity, whereas direct and indirect losses could be included in a broadly drafted indemnity. An example of a broadly drafted indemnity can be seen on the screen there. It says all damages, liabilities, demands, costs, expenses, claims, actions and proceedings, including all consequential, direct, indirect, special or incidental loss, etc., etc. That's a broadly drafted indemnity. So it covers both direct losses, indirect losses, incidental losses, special losses, consequential losses. How enforceable is it? It will depend on the strength of the party giving it. He can take out insurance to cover it if he wants, but if you get an indemnity from, for example, a small builder and perhaps who has a limited company, and you're getting an indemnity from a limited company, and the company may not be around all that long or may not have significant resources available, then clearly the strength of that indemnity is questionable. Indemnities can arise by operation of law. For example, an agent is indemnified by his principal. They also arise in contracts, and they can be enforced for a period of 6 years from the date on which the indemnifier refuses or fails to honour the indemnity. So that point in time where the indemnifier refuses or fails to honour the indemnity triggers the cause of action to sue for breach of contract or to sue on foot of the indemnity, and that would be for a period of 6 years from the date on which that refusal is triggered. You need to ask yourself the question, is there a need for an indemnity? You could see, for example, if you can rely on simply suing for breach of contract or breach of a warranty, for example. So you may not always need an indemnity. You may just rely on suing for breach of contract. You may also have a statutory remedy open to you, but the effect of an indemnity then should be to give rise to damages for breach of contract or damages generally. You also need to check if the effect of the indemnity in a breach of contract will give rise to other remedies, for example termination of the contract or compensation reimbursement. Hope you find this video useful. My contact details are on the screen. If you do find it useful, I would appreciate if you gave it the thumbs up down below.